involve exactly the same issue, correct?
There is one unique aspect to the Oaks case that I will reserve until that case is called. But the central legal issue is the same in both cases.
And if that central legal issue is decided, does that dispose of both cases? Or
No,
is there some wrinkle in Oaks that might take it outside of this?
There would be a further step in the Oaks case.
See it, but all right.
May it please the Court, I'm Assistant Attorney General Rob Quinnen for the Workers' Compensation Trust Fund. The legislature has never expressly stated, nor even reasonably implied, that no statute of limitations should apply to mid-act cases. More particularly, the 1985 legislature, which created insurers' claimed right of reimbursement from the trust fund, expressed no intent to give insurers a right in perpetuity to file Section 37 reimbursement petitions unbounded by any rule of timeliness. Where a statute provides for a claim or right of reimbursement, but the legislature has not specified a limitations period, and it has not plainly indicated that none should apply, then this Court has repeatedly stated that tribunals are duty-bound to identify and apply a suitable rule of timeliness. Accordingly, the lower tribunals here should have looked to the gist of the insurer's reimbursement claims and applied an appropriately analogous limitations provision. This Court has repeatedly rejected arguments that the absence of an express limitations provision in a given statute means that no statute of limitation applies. Because of the important policies a rationally administered trust fund serves, including timely resolution of claims and fair assessments on employers, the legislature would not have deprived the trust fund of the protection of some time limit for filing reimbursement petitions for mid-act cases.
Mr. Quinn, here in 2007, do you have any, can you give me any indication of what's the universe we're talking about? In other words, people that were injured between 85 and 91, I guess.
That's right.
And where the claim is still operative for that, you know. Can you just
Well, in all of those cases, the claims would have accrued at least 15 years ago now, and yet petitions are still being filed.
That's what
in
I'm asking.
2006, 2007, yes, there have been 100 or so petitions filed in just the past year.
But for this gap period?
Yes, for the 1985 to 1991 period. And there was a big spike in fiscal year 2004 where, in fact, the mid-act petitions going back 15 years exceeded the number of petitions associated with post-1991 claims. So there's a lot of these claims.
One other question.
Sure.
The regulation that was in effect until 97?
Yes.
Is that right? While that was in effect, did anybody challenge it in terms of it was ultra-virus because there was nothing in the 85 statute that provided a statute of limitations?
No, there was no challenge, to my knowledge, to that regulation, and I believe that any such challenge would have failed because there's a number of cases that say that administrative agencies, the labor relations case, the Miller versus labor relations case, says that an agency that handles a large number of claims, if it's given statutory authority to promulgate regulations for the orderly processing of claims, that includes the right to set time limits for the filing of claims.
If you had not, I'm sorry.
Oh, no, go ahead.
If you had not, I don't mean you, if that regulation had not been repealed, I guess is what it was in 97, wouldn't that govern in this case?
Yes, it would.
So why was it repealed?
Well, there was an effort in a prior administration to remove all what were deemed extraneous regulations from the Code of Mass Regulations, and by mistake, this was viewed as an extraneous regulation, and it was repealed.
You've got all these signs that Mr. Ben-Ezra's position may be correct. The lack of any explicit limitation period until 1991, when the legislature puts it in and expressly denominates it as substantive.
Well, I could address that. There's no inference that should be drawn from the lack of a limitations provision in mid-act version Section 37, even given the presence of limitation provisions elsewhere in Chapter 152. The insurers do argue that 152 is replete with limitations provisions, and the legislature has always included such a provision where it intended one. That's not factually accurate. In fact, our appellate courts have recognized at least 3 sections of Chapter 152, other than Section 37, that create claims but contain no limitations provisions. And in each instance, the court did not assume that no time limit governs, but rather it identified an applicable general statute of limitations outside of Chapter 152.
Okay, but here, let me get back to the questions that Justice Botsford was asking. I take it, and I thought I read this in GM's brief, that for a period of time, the Industrial Accident Board was in fact relying on a no statute of limitations situation, at least before I think the regulation was promulgated, so a period of 5 years from 1985 to 1989. Is that accurate? I mean, were there...
No, that's not accurate. There was a regulation setting a 2-year time filing that was coextensive with the beginning of eligibility for reimbursement in the mid-act period.
Because the one in the record, or in the brief, says on the bottom 1988, so I didn't know whether that was when it was promulgated or that was just the version that you have in there.
It was first promulgated and made effective as of November 1st, 1986. No insurer would have had eligibility for reimbursement in a mid-act case prior to November of 86 because the first 104 weeks are not eligible.
So for the period from the relevant period of the operation of this statute, the reimbursement statute, from the time it was enacted up until 1997, if there was any ambiguity about whether there was a statute of limitations, the administrative agency filled that ambiguity by promulgating a regulation that created a 2-year statute of limitations.
That's right, Your Honor. Now, there's a wrinkle in that regulation was also amended to make it inapplicable after the mid-act period to claims filed before January 1st of 1991, I believe. But when the Oaks and the Alves causes of action accrued, the regulation you have in the record is the one that governed. It was in place at that time. It had a 2-year statute of limitations. That's what the insurers would have known they would have to operate under.
Yeah.
They would have to file their petition within 2 years, and then it was repealed.
Do we know why a 2-year period of limitations was selected?
No, we don't.
There's no history that can be found anywhere?
Not that I have become aware of, no.
Okay.
Explain the wrinkle again, the 1991 amendment to the regulation.
That's right. And it was around the time that the legislature then amended the statute to create a rolling prospective 2-year statute of limitations.
Which was just like the regulation, right? It was also a rolling prospective.
That's right.
And so how was the regulation amended
Yeah.
at that time?
Yeah.
It provided that for cases brought after 1991, this is the regulation that would apply.
So it basically no longer, on its face, no longer applied to cases brought between 1985 and 1991.
That's right.
So was there a mistake that was made? I mean, in the conclusion that this was extraneous?
I believe that the thought was that all petitions that were eligible for reimbursement would have been filed by that time, and therefore, and particularly with the new statute coming into place, it was not necessary to have a redundant regulation. Now, it turns out it wasn't redundant, but that was an error.
For legislative history, any discussion about this 2-year statute of limitations and what the intent was, whether...
No, Your Honor. I have looked for any type of legislative history that would shed light on why 2 years was selected or what the legislature's intent was in putting that provision in, and I could not find any relevant documentation.
But the fact is, there may be no legislative history, but one can look at the regulation which was in place and the statute which was enacted, and they are pretty much the same, aren't they?
Well, they are the same, essentially, yes.
Yeah, so one might draw the inference that the legislature was adopting the statute, the regulation into the statute.
That's right. That is certainly one possible reference. But to step back to what the 1985 legislature did, at that point, they created this right of insurers for reimbursement. They did not put any express limitations provision in the statute. They may have either been aware of the regulation or the plan for regulation and therefore done nothing, or they may have considered that the general limitation governing claims against the Commonwealth, Section 3A of Chapter 260, applied, and it is very close.
But how could they have been anticipating the regulation? The statute was enacted in 1985, and the regulation was promulgated in 1989.
I don't know whether, as part of the process of legislating, they had an understanding with the affected party that there would be a time limit done by regulation. I'm
I thought you said it was
speculating on that.
November 1st, 1986.
Yeah.
The
The
regulation.
regulation,
Is when it became effective.
November
But-
1st, 1986.
Justice Spina just
Right.
said 1989. Is that
Yeah.
correct, or 1986?
It wasn't-
1986.
It was 86.
86. So, and of course, in 1985, there was always the background rule, the common law rule, that in all, applicable to all classes of civil cases, that claims must be presented in a timely fashion. The legislature is presumed to know the decisions of this court, including the Nantucket versus Beinecke case and other older cases, City of Boston versus Gordon, where the legislature says if a statutory provision is silent, the courts will identify and apply a statute of limitations. So there's nothing to be read into the 1985's creation of this right and no associated limitation provision. Certainly not, it's not appropriate to draw the suggestion that no time limitation provision was intended.
Now, when the 1985 statute was enacted, was there a 4-year limitation on employee claims? How did that work? Did that exist in the 1985 legislation?
Your Honor, there has always been a time limit on when injured employees must file their claim. It used to be a 1-year statute of limitations. It was amended to become a 4-year statute of limitations, and it was, I believe, part of the 1985 reform.
Can I add another point?
Yes.
We've got case law, which I'm sure you're familiar with, that says we give great deference to the board's decision. And I'll now quote, "The party seeking to overturn the board's decision bears the burden of proving that the decision is invalid, and that burden is a heavy one." How can you meet it on a case that is muddled up as this, that the board was wrong?
Well, this reduces to a pure question of law,
Yes.
and it's for the courts to ascertain the correct question of law. Here, the reviewing board made
But
two
there's
crucial reversible errors of law.
Oh.
Number one, by ruling in effect that legislative silence on the time limit associated with insurer reimbursement petitions in the 1985 Act, where there are time limits in other parts of Chapter 152, some other parts, but not all, that means that no time limit applies, and that is not the law of this court.
Well, they said a little more than that there was a little more than silence. The amendment was designated as substantive.
That you're talking about the 1991 Act. I'm talking about the 1985 Act.
Oh.
In 1985, and that actually gets to my second error of law by the reviewing board and the appeals court.
Well,
They failed to.
But before you get to that, let me just stick with the statute of limitations for one more question. Administrative agencies can make law not only by regulation, but by case law, by decisional law. Have any decisions come down administratively between 1997, when the regulation was repealed, and up until today, in the last 10 years, in which, as a matter of administrative case law, they have consistently held that there is a 2-year statute of limitations on these cases?
On mid-act cases?
Yeah.
Well, it's the Walsh case, which gave rise to this case, where they said that, no, there's no time limit whatsoever.
It went the other way.
It went the other way. Yeah.
But again, I'm saying they made a mistake, the reviewing board in this case made a mistake, and frankly, even the appeals court made a mistake.
Was the Walsh case the first case to say there was no statute of
Yes.
limitations?
And that was in
Yes.
2002, and
And that was in 2002.
So I'm focusing on 1985,
Right.
and what a reasonable person would have understood in 1985.
Exactly. We need to look at what the legislature intended in 1985, and the second mistake that everyone has made is by failing to recognize that post-enactment legislative history is an oxymoron. When my brother counsel argues that the 1991 legislative amendment has some bearing on the question of how you apply the 1985 Act, that's an improper line of analysis, because you're saying that the legislative history associated with the 1985 Act is conditioned by something that happened 6 years in the future. And of course that can't
No, but
happen.
there's another way of looking at that, which is to say that the legislature in 1991 couldn't ascertain, different legislature, couldn't ascertain what happened in 1985, and decided that it was sufficiently muddled that they were going to expressly make their rule, forget about whether substance or procedural, they actually said this is prospective.
But also there was a regulation in place, which they would have been aware of, that had the same 2-year statute of limitations effect.
Thank you, Mr. Quinlan.
Thank you.
Mr. Ben Esler?
Good morning. My name is Jerry Ben Ezra. I represent Travelers and
So you've only got
General Motors.
So you're doing both, right?
I'm doing both, yes.
Okay.
What I can do is, I'm sorry, I thought I'd spoken to the clerk. I'm very happy to hold my argument. Have you completed both?
To do the wrinkle in the other case?
What Mr. Quinlan wants to do is to get up and have...
Yeah, I just soon have him do that, and I can argue them both in 15 minutes. I don't need
Fine.
extra time, if that's
Okay.
okay. It just makes it simpler.
No, you go ahead.
Okay.
And then, you know, if you want some additional time, you're going to get 15 minutes, and if you want some additional
Okay.
time, you can come back up again.
I think I'm going to have a perfect record today insofar as in 30 years of doing this, I've never been able to argue the case I prepared. So what I'd really like to do, because I think it'd
Is
probably
ask us
be,
what our questions
be
are.
most helpful, is to answer your questions rather than re-talk
We have
about
read your
my
brief.
strengths. Yes, I realize that.
Okay.
So if I could, I'd just like to give an overall discussion, which I think covers a lot of your questions, because I think this is rather unique, which is the point we try to make in our brief. When you're doing legislative interpretation, it means you're looking at a particular statute. And I think that's the default position. And then you decide, is there a reason to look outside the statute? And I don't think you find that here. But let me see if I can just put this in concept, because I was around in the Walsh days. I actually argued that case. Because I think that's really what we're doing. And just so we're clear, this has been around since then. I probably would have been the one to argue the regulation case if I had. The regulation argument they made was taken care of rather quickly in Walsh, which, by the way, was not appealed. So this is really not a summary decision. This goes back to a case which really was the one which was the father of all these. And at page 95, they basically say, the trust fund's passing reference to the regulation, no passing reference, because I think this is important, because they keep on losing and they keep on coming back with new arguments, including some today that I've heard for the first time today, which I'll talk about in a second. The trust fund's passing reference to the regulation, repealed as of January 10, 1997, which provided a statute of limitation for dates of injury on or after January 1, 1991, is also unworthy of serious attention, as the injury date here clearly does not fall within its coverage. Now, I think the point is that we should only be forced, that is the folks who represent claimants, to answer the cases before you. So what you really need to do when you look at this, and by the way, when you look at the appendix to my brief, where I show you the summary of argument and I show you their issues, borrowing was not made, that issue was not raised before the full panel. It was waived for the reasons we set forth in a brief when we give you the case law. So I think what's important really is to put this in context, because I think part of this, at least the history of this case, is if these arguments were so good, why didn't they make them before? On the many occasions they had, and I also give you in my brief the record references to the times that they've had an opportunity to raise these arguments and didn't do so. So now what we really are, and I was accused once before by one of the justices up here of mixing metaphors, but we're really scraping the bottom of the barrel for arguments, and that's where we are with the borrowing argument. So let me see if I can just address the points that were made in response to the questions you had, because what we're talking about here, and I think it's just a minute of history, is we used to have common law torts. Legislature comes in and says, workman's compensation, we have a public policy here, we're going to streamline this, and we're going to change the rules on this. You're no longer going to have your common law right, which, by the way, takes care of a lot of the cases that they cite.
What about the original workers' compensation statute about
Back
100,
in the
100
early,
years ago?
yes, the statute itself, 152, the Act. And I think what's important then is that they then go forward and they create these rights and they pay a lot of attention. They did a major rewrite, among other times, but for our purposes, in 1985, 1986, which we've been talking about, and in 1991. And by the way, if you read the Walsh decision, you'll see that this emphasis on 1985, again, is something new. It wasn't made below, it's made now, and I'm happy to deal with it because I don't want to have to come back a year or two from now. But again, I think it's important to put it in context. So what the legislature does in 1985, and both the Judge Cowan's single justice opinion, which was an appeal, deals with this, and I can give you the references if it would be helpful, but in the time I have, I can come back to that in a second. But in the record, both there and in the Walsh decision, what we have is a situation where we're really concentrating on the argument they were making at that time that 1991, that the Reform Act should have been applied to mid-act cases. In other words, we all refer to as the new act, which was post that 1991 should be applied to the mid-act cases, which is 1986 through 1991. And that's really the thrust of it, and that's why you have the wording you have in the decisions, both by the single justice who addressed this issue and by the reviewing board in Walsh.
Point that Mr. Quinnen shouldn't be able to argue what he's
No,
arguing here
I'm
today?
willing to take it on, but my point is that we need to take these things in context, and I just don't want to be penalized for the fact that a lot of this is not in the briefs. I'm willing to take it on today because it'll come back. But I need to not be criticized, nor do I think that if we're talking about an appellate court looking at, forgetting about deference for a second, we're looking at did they err? And I think if you were to make a matrix of all the arguments we make and all the points that were made by the single justice and all the points that were made by the reviewing board in Walsh, and you looked at those arguments and you looked at how they distinguished the cases, some of which were cited again today, you'll notice they never have never addressed the arguments. They're looking at this as almost as it's de novo, and you need go no further, for example, than page 94 in the record where the Town of Nantucket case, the Beneke case, which they just referred to, was distinguished. It's distinguished, not brief. It was distinguished by the single justice. But we're up here again, arguing that case, telling you that case stands for a general proposition that silence is not enough, and if you're silent, you have to borrow. And when you take a look at these decisions in our brief, you see why that rule doesn't apply, and yet they're still wrapping their arms around that life preserver of that rule. And so when you put this in context, let's talk about 1985 or 1986. The legislature, as I think Judge Cowan said, and I believe it's both in the Walsh decision, but I know Judge Cowan said it. He talked about she did. They talked about the statute being rife, R-I-F-E, rife with references to where there were rights that created, the statutory rights. We're going to give you, we the legislature, are going to say, in this one you're statute of limitation, in this one you're statute of limitation, in this one you don't.
But Mr. Benezra,
yeah.
Can you articulate any rational reason why employees should have a limitation, but the employers should be able to claim against the Commonwealth forever?
Yes. Actually, I think I can. Among others, is the policy behind the Workers' Compensation Act was we're going to take away certain rights. There's proof that you need to have when you talk about a workers' compensation case. It's very similar to a tort case, even though it's now a statutory action. In these cases, you'll note there are no facts being argued. These are really cases that deal with paper in almost every regard, if you take a look at the statute.
Well, they
And
agreed
so-
that the injuries fell within Section 37.
That's right. And then what happens is the legislature says, all right, we have a policy. And the policy in the Second Injury Fund is that what we're going to do is we are going to try to encourage employers to hire previously injured employees. That's a different policy. And they make a decision at that point that as to these claims and the way we've structured our statutory scheme, we're not going to do it. And the reason I think that this is a little different than the other cases they've cited for looking at what happened in 1991 is we say, and the court says, and the appeals court says, as well as the Walsh case, that the legislature knew what it was doing, and I'm looking at page 153 in the indented quote, if the legislature felt that the trust fund would have been prejudiced in some way that required retroactive application of the new limitations period, then it could have enacted a retroactive limitation on petitions, an action it specifically chose not to do here.
But the regulation was in place, right?
The regulation was in place.
Well, the regulation was in place, but did not become problematical for any case that at least my client was involved in. Which if we're going off the record, I think they'll agree is we're the 800-pound gorilla here. We file most of the claims. So the regulation issue, that's why you have no decisions on it. It wasn't an issue that was problematic at the time.
What do you mean it wasn't an issue? It wasn't an issue because
It just wasn't coming up as a bar to claims that weren't being settled or otherwise taken care of.
Maybe
Do you
that's
mean
because
they
the
were
claims were being
ignoring it?
filed in a timely fashion.
Yeah.
I mean, isn't it the case that all of these claims have come in now because Walsh said there was no statute of limitations, which has now opened the floodgates?
No, I think really what happened is, and I'm reticent to go off the right, I think what was happening was cases were being settled, and it wasn't problematical. And I mean, I was feeling very uncomfortable going off the record, but if you're asking me that question, and it may be an issue here, I think that there's actually either a published decision of this court, or I know there's a public document that talks about the fact that there were delays in them settling cases, but there were periods of time when cases weren't coming up. And I think that if that became an issue, I'd be very happy to research that and get back to you on it. But I don't think the regulation was problematical for the major companies that were making claims at the time.
Well, that's because it's not problematical. I mean, statute of limitations are a way of life. We meet them all the time.
Yeah, but I think cases were actually being settled regardless of the regulation.
You were going to tell us about a policy that justifies no statute of limitations.
No, I think
what is the policy?
I think that I was asked about the difference in the policies between the core workers' compensation and the second injury, and this court has said on many occasions that the purpose for the second injury law is to encourage employers to hire.
That doesn't mean you can't have a time limitation on making the claim.
No, I think the issue is that it's a legislative prerogative, and they have the right to make that decision. And I think both the single justice and I think the appeals court, and I think this court in many cases have said we don't fill silence. We don't get involved in judicial legislation.
But what do you make of Locator and Woodward, two cases very much on point and relevant to this that we've decided recently?
Let me take Woodward as an example, which is the subpoena case in the MCAD. Let's say, for example, if actually a little different. Let's say that there were 4 classes of discrimination, A, B, C, and D. And as to A and B in 1986, they say we're going to have statute of limitations. And as to D, I'm sorry, we're going to have a subpoena. And as to D, we're not. And then in 1991, they say, we changed our mind. As to 1991, we're going to allow you subpoenas for Class D. Now, I'll tell you why this is important, because if they make the argument that the legislature has to be aware of your decisions, they're certainly aware of what they've done before in this act, which is not an inconsequential act. And if they're aware of what they've done before, and they make a conscious decision as they did here, which is not the Locator case, and which is not the Woodward case, and they say, we understand what we're doing here. We're specifically paying attention as to where we're going to be retroactive and where we're not. But, in the middle of that cases where we're silent, we were silent because we didn't want anything there. And now that we've decided we're going to have one, we're not going to make it retroactive.
But there was a regulatory statute of limitations in place for 10 years. If this public policy that you're talking about was so important, why didn't the legislature amend the statute to say there is no statute of limitations?
I didn't think it was 10 years.
1986 to 1997.
Maybe it was.
11 years.
I will tell you, quite frankly, since it wasn't, I didn't realize that was going to be a major issue here. So my position on the regulation is it's procedural. It's when you file the claim. It's repealed as of the time claims have been filed, and then for purposes of those claims, I think that you have to look at if a regulation is in place. And I think that the regulation shows 2 things. It showed they didn't feel there was a statute of limitations at the time, which is why you only see them, which is why you don't see it being discussed in Walsh or in the single justice case. I think that that everybody recognized there was none, so they said, we're going to fill this gap, the fund did, and we're going to do it by regulation.
Well, that's right. I mean, there wasn't one, so they did.
There
There was not a statute.
That's right.
And so they did fill it by regulation.
They filled it by a regulation which they repealed, and my position has been, and as I say, I'm not trying to avoid the question. It's just this has not been a major issue since
So
Walsh.
if the regulation is in place, when your claims are filed, aren't they out?
No, they weren't. It wasn't in place, though.
Well, I think the problem there, quite frankly, is, and this is where I would respond to your question, that I think I would rely on the doctrine that you can't raise things for appeal at the first instance, because I'm really kind of blindsided. Because if that had been really an issue at the time, I would have been the person who would argue it, and I can't create all those arguments and do all the research on my feet.
This whole regulation thing has been waived, right?
It's reappeared. It's been resurrected, but not in either of these cases.
you mean it was made
It was made in Walsh. They basically reacted to it the way we said. It was not raised in the Oaks case before the full panel. I mean, I'm not really what I'm concerned about, quite frankly.
Clearly not discussed at all in the appeals court.
No, I gave you the
But
brief.
we're talking about Alves, which didn't go to the appeals court, right?
Yes, I understand that. But all I'm saying is today is the first time I recognized, based on anything I've seen, that regulations was going to be a major issue. I saw it as being all of these other issues. We have never litigated that issue fully, other than before.
It's an issue only insofar as it applies to the legislative intent in 1991. You say they certainly didn't intend that there be a statute of limitations for that prior gap period, or they would have provided it.
Well, I'm
But
saying
there's a regulation in place which actually covered that period, so why would they need to provide it? I mean, it bears on legislative intent, I suppose.
But Walsh killed it off.
it
Walsh
did.
killed that argument.
Well, it did. I'm not going to tell you as I stand here that I remember all the arguments we made back then. I do know, as I've read to you, the way they dealt with it. All I'm saying is that this is a major case, and I'm willing to be here. You've noticed I've indicated where, quite frankly, this should be Oaks. It's Alves. It kind of got backdoored in here.
Well, I'll tell you what we're going to do, Mr.
Yeah.
Benessa. Mr. Quinnen wanted to have 2 lots of arguments, but
Yes.
that leaves you a whole other 15 minutes, in
Right.
about 15 minutes' time. Now, Mr.